Hey everyone! Always remember, ignorance of the law excuses no one. This is Legally Engineered. Take note guys na when you're a supposed buyer of a, let's say, a lot, no? It's enough for you to just look at the
Certificate of title.
Kapag kita mo namang malinis, you are not required by law to look beyond pa. Diba? So, yun yung rule dyan. Alright, Attorney Uy, so we're done discussing Articles 1163 and 64 of the Civil Code. Now, we proceed to Article 1165. Ano ba sinasabi ng Article 1165, Attorney?
So, when what is to be delivered is a determinate thing, the creditor, in addition to the right granted him by Article 1170, may compel the debtor to make the delivery. If the thing is indeterminate or generic, he may ask the obligation be complied with at the expense of the debtor. If the obligor delays or has promised to deliver the same thing to two or more persons who do not have the same interest, he shall be responsible for any fortuitous event until he has effected the delivery.
So, kanina kasi sa 1163 and 64, pinag-usapan natin ang rights, duties ng debtor. Sa 64, rights naman ng creditor.
To the fruits.
Ngayon naman, paano kung may breach nga dyan or may ayaw mag-comply or hindi na-comply, ano ngayon yung remedies?
Yes, so
ni
Article
creditor?
1165 talks about the remedies of the creditor in real obligation, whether it is generic or specific.
So, in a specific real obligation, for example, an obligation to deliver a determinate thing, the creditor may exercise the following remedies. May
Merong tatlong options ang creditor when it comes to a specific
real
obligation.
First of which is, of course, to demand specific performance or fulfillment of the obligation with a right to indemnity for damages.
Yeah, so first, it presupposes na walang non-compliance by the debtor in a specific real obligation.
So, hindi nag-deliver, kailangan nang i-deliver, di mag-demand ka with specific performance mo ng fulfillment ng obligation na meron.
So, first remedy is to demand specific performance or fulfillment of the obligation with a right to damages. So, ibig sabihin, i-demand mo na i-deliver sa'yo. Ganon.
Tapos, susunod doon, demand rescission or cancellation of the obligation also with the right to recover damages. Kasi pwede nang hindi kasi i-deliver o hindi na, impossible na to deliver.
I-cancel mo na lang, mag-rescind ka na lang. Demand rescission or cancellation with damages din.
Yes. And yung
the
pangatlo
third option
is to demand the payment of damages only where it is the only feasible remedy.
Yes,
so kapag hindi na ma-deliver or hindi na rin naman ma-rescind yung
hindi na feasible.
Hindi na feasible.
So the only remedy is the payment of damages.
Yes. So take note guys na in an obligation to deliver a determinate thing, the very thing itself must be delivered.
Kasi nasabi nga natin din kanina sa ating previous discussion, it cannot be substituted with another without the consent of the creditor. So, ibig sabihin, the very, very thing itself must be delivered.
Yes, and consequently, only the debtor can comply with that obligation.
Kasi
diba?
unique siya, unique yung thing.
And this is the reason why the creditor is granted the right to compel the debtor to make the delivery, which is the first remedy available. I-compel mo, pwede mo yung i-compel na mag-deliver sa inyo. And it should be made clear, however, to the students there that the law does not mean that the creditor can use force or violence upon the debtor. The creditor must bring the matter to court and the court will be the one to order the delivery. So for example, balik tayo kay Kokoy at kay Jam, di ba? So on September 27, Kokoy is supposed to deliver the horse to Jam. So here comes September 27. On September 27, Kokoy did not deliver the horse to Jam
for whatever reason.
So
hindi niya dineliver.
Anong rights ngayon doon or remedies ngayon?
So una, ang aanihin ni Jam is to deliver to demand the delivery of the horse for specific fulfillment. Pangalawa, kung wala na namatay na talaga. So, hindi na talaga may i-deliver specific horse, di rescind or cancel.
With?
Oo, with damages. Or kaya, pwede din naman damages na lang. You don't need to receive.
It's the only feasible remedy. Alright.
So, how will you characterize yung remedies na to? Pwede bang, kagaya ng kanina, yung example kay Coco at kay Jam, pwede bang si Jam as a creditor, pwede ba siyang sabay-sabay o demand the fulfillment? O kaya magka-cancel? O kaya damages na lang? Pwede bang ganun? Sabay-sabay niyang hingin yung remedy na yun?
These remedies are actually in the alternative.
Yes.
Ibig sabihin, you cannot avail all of these remedies at the same time. So, if, for example, nag-avail ka ng demand specific performance, you cannot avail rescission.
Yes.
Kasi it's absurd na you're demanding the delivery at the same time you're canceling the
so,
obligation
one
itself.
at a time lang yan.
One at a
Kung
time.
gusto mo talaga na i-deliver sa'yo, di mag-demand ka ng fulfillment. Oo, pero kung fulfillment with damages. So, hindi pwedeng mag-demand ka na ng fulfillment, tapos mamaya mag-re-rescind ka. Unless it is the only feasible remedy. O kaya, ang una mong diniman, ika-cancel ko na lang, hindi na pala. Tapos mamaya nagbagong isip mo na i-deliver na. Hindi pwede. You only elect one. The election of one of the remedies excludes the, or it will waive the other remedy.
So take note of that, guys. And yun nga, ang sinasabi nga natin dito, yung remedy na to sa creditor, it doesn't mean na ina-empower or ina-authorize ng law ang mga creditors to take force or violence upon themselves, no? Na sasakalin mo kapag para mag-deliver.
O kaya tatakutin mo.
Pag halimbawa, Attorney Uy, kay Kokoy at kay Jam, nasabihan naman na nag-demand na siya na i-deliver yung horse, ayaw pa din. Pwede kang sugurin ko si Kokoy, may dala akong shotgun at lumabas ka dyan.
Kasi it will result to a criminal liability.
Kakaroon ka pa ng obligation.
Pwedeng grave threats.
Oo, grave threats. That's a delict. Diba? So, huwag niyong gagawin yun, guys. What's the remedy?
Do not use force.
You go to court.
You go to court.
Yan yung sinasabi na don't take the law into your hands. Okay? So go to court. Doon tayo mag-usap. At tawagin niyo kami.
Yes. At saka nakalagay pa doon, in case of rescission, the parties must return or restore to each other what they have received. For example, si Coco hindi nag-deliver, nagbayad si Jam. Ibig sabihin, si Jam, halimbawa, hindi nagbayad si Jam, si Coco hindi nag-deliver. So Jam, pwede niyang i-elect yung demand rescission or cancellation of the obligation, in which case dapat ibabalik ni Coco yung pera na binayad ni Jam plus may damages pa.
Yes.
So 15,000 pesos plus damages.
So, Attorney, siguro linawin ko lang din yung kanina yung sinasabi natin na yung rights to demand fulfillment and rescission with damages, they are alternative, sabi ko nga, and at the same time, not cumulative. So, linawin lang natin yung term is alternative, not cumulative.
Pag cumulative kasi, both remedies pwede mong gamitin. Pag alternative, isa lang doon, mamimili ka lang.
Huwag ka namang
huwag salawa.
Wow.
Dapat, lang.
Stick to one. Alright, so
panindigan kung ano ang pinili.
Yes, take note of that, guys. Okay? And we're done discussing yung remedies of creditor in specific real obligation. Now we go to rights of remedies of creditor when it comes to generic
real obligation or the obligation to deliver a generic thing.
In this case, it can be performed by a third person. Yan. Since the object is expressed only according to its family or genus. So, necessary ba dito, Attorney Oy, that the creditor shall compel the debtor?
So, dito, sa hindi specific performance ang remedy ng creditor kapag ang obligation is to deliver a generic thing. Kaya nga, specific performance, remedy lamang siya kapag in case of non-compliance, kapag specific real obligation. There is no specific performance in a generic real obligation. Hindi pwede. Kasi, your remedy there is pwedeng to ask a third person to fulfill the obligation at the expense of the original debtor. Oh.
So, in that case, ano bang pwede natin maging example dyan na attorney dyan sa generic real obligation?
Oh, for example, yung horse na, yung kay Coco at Jam pa rin, hindi specific horse,
Yung
kundi
horse.
any kind of horse. Oh, halimbawa, brown horse lang ang sinabi.
And
Or white horse, for
sabi
example.
natin may 50 white horses si, si Coco.
Si Coco. Oh.
Coco ba? Coco. Whatever, Coco ba?
Whatever, basta Coco.
Yun, so may 50 white horses si Coco.
Oo. Oh, edi,
Nangyari doon?
for example, may 50 horses. Hindi naman on September 27 pa rin ang date of delivery. Hindi nag-deliver si Coco on September 27 kay Jam. Ang tanong, si Jam ba pwedeng mag-ask ng specific performance kay Coco? Hindi po, kasi wala pong specific performance kapag generic real obligation. Generic dahil generic lang yung horse. Brown horse lang ang minention. Hindi naman specifically designated or physically segregated yung nabanggit. So, pwedeng under Article 1165, may remedy din doon na kapag generic or indeterminate thing at hindi nag-fulfill ang debtor, he may ask a third person to fulfill the obligation at the expense of the original debtor, which is, who is Jam. In this case.
Well, in this case naman, in any case, yun nga, the creditor has the right to recover damages under Article 1170.
Yun ang common sa kanila, laging may damages, either specific or real obligation.
Alright, Attorney Way. So kung mapapansin natin, under 1165, particularly paragraph 3, there's a mention there that if the obliger delays or has promised to deliver the same thing to two or more persons who do not have the same interest, he shall be responsible for any fortuitous event until he has effected the delivery. So, ano ba ibig sabihin ng clause na ito, Attorney Boy?
So kasi, ang general rule natin dyan, kapag may fortuitous event, yung mga acts of God na tinatawag natin, yung mga force majeure, fortuitous event.
Inevitable, cannot be seen, or if foreseen, cannot be avoided.
Yan yung mga fortuitous event natin. Generally, kapag may fortuitous event, exempted from liability ang debtor. Mai-extinguish ang kanyang obligation.
As general rule.
As a general rule lamang. However, under Article 1165, paragraph 3, meron tayong two exceptions to the general rule. Yung first clause is that when the obligor delays, ibig sabihin, pag may delay in the delivery of a specific thing, kahit may fortuitous event, liable pa rin ang debtor. Ang pangalawang exception, when the debtor has promised to deliver the same thing to two or more persons who do not have the same interest, and the thing is a specific thing, even if there's a fortuitous event, hindi ma-exempt from liability ang debtor.
Kasi
ibig
nga
sabihin,
naman,
may liability pa rin.
Kasi nga, in the event na ipinamis niya ngayon dun sa two or more persons who do not have the same interest over the same thing, kapag i-deliver na niya dun sa isa,
it is impossible.
Magde-default naman din siya dun sa impossible to deliver.
To deliver kasi nga, specific thing, isa lang. Isa lang kasi yung specific thing. So, ibig sabihin, for example, kami dalawa ni Attorney Maralit, magkaiba yung interest namin. So, for example, meron kaming debtor. Ang sabi ni debtor sa amin, Attorney Maralit, bibigyan kita ng gold watch. For example, specific gold watch.
Okay.
Bibigay na kay Attorney Maralit. Tapos, yung same debtor, sinabi niya sa akin na, Attorney, bibigyan din kita ng specific gold watch.
Same.
Same lang yung specific gold watch. Isa lang yung pinapertain niya. Tapos, halimbawa, sa akin siya nag-deliver nung specific gold watch. And then there has been a fortuitous event. Dinadeliver na sa akin, may fortuitous event. Will that exempt the debtor from liability? The answer is no. Under Article 1165, paragraph 3. O, hindi mag-a-apply yung general rule.
Halimbawa, Attorney Oy, dyan sa binigay mo example, halimbawa, when the debtor is about to deliver the specific gold watch, he was robbed. Halimbawa,
okay.
nanakawan
Yun naman,
siya,
hindi
diba?
pa to na-deliver.
Hindi pa na-deliver.
Kahit isa sa amin, walang na-receive na kahit ano. He is just about to deliver to any one of us yung gold watch. Tapos, hindi pa nga nandi-deliver, nagkaroon ng fortuitous event. For example, COVID. O ECQ pa nun. O, can he invoke the defense na siya na may fortuitous event, so hindi na siya liable sa aming dalawa? The answer is no.
Yeah, the answer is no because again, that is an exception to the general rule that in the event of fortuitous event, the debtor shall be exempt from liability.
Yes.
Because it would fall under paragraph 3 of Article 1165, which provides that when the debtor promises to deliver the same determinate or specific thing to two or more persons who do not have the same interest over the same thing, he would still be liable even if there is a fortuitous event.
Correct.
So, kasi nga naman, kahit walang fortuitous event, na-deliver niya kay Attorney Oy, hindi niya ma-deliver sa akin. So, or kung ma-deliver niya sa akin, hindi niya ma-deliver kay Attorney Oy.
Talagang may breach.
Merong default or breach.
Kasi nga, iisa lang kasi yun yung specific thing. Tapos, i-deliver mo sa amin dalawa. We have different interests or we do not have the same interest. So, that would be a breach of the obligation. Yun namang una, yung delay.
Delay.
For example naman, si Coco at si Jam ulit, September 27, yung delivery date. Ngayon, si Coco hindi nag-deliver ng specific course on September 27.
Reason?
Tapos nung September 29, nagkaroon ng fortuitous event.
Pumutok
ang
Bulkan Taal.
Ang Bulkan Taal. For example, pumutok ng September 29. So, will that fortuitous event exempt Coco from the delivery of the specific course? The answer is no. On legal basis, Article 1165, Paragraph 3, first clause. Sabi doon, kapag may delay, the fortuitous event will not exempt from liability.
Yes. So, in that case, the materiality would lie on which comes first. Is it the fortuitous event? Yung reason kaya talaga nagka-delay, or even in the absence of fortuitous event, talaga naman may delay siya. So sa example na binigay ni Attorney Uy, on September 27, there has already been a delay. Fortuitous event only happened, the eruption of Taal volcano on September 29.
After the stipulated date.
Yes, that's after the stipulated date of delivery, or that's after he has already incurred in delay. So,
pero kung yung fortuitous event nangyari before September 27, you will apply the general rule.
And dapat yung fortuitous event is still ongoing at the time halimbawa, September 27.
Okay.
Kasi pwede namang September 25 nangyari yung Bulkan Taal na pagsabog. By September 27, pwede naman na talaga mag-deliver. Hindi pa rin. So, dapat prior and subsisting at the time the obligation to deliver arises. So, take note of that, guys, kasi isa rin yung source ng dispute when it comes to debtor creditor, and we will tackle more comprehensively the topic of fortuitous event sa susunod na articles.
1174.
At this juncture, Attorney Uy, it's important to emphasize sa mga viewers natin na ang paragraph 3 of the Article 1165 pertains to determinate thing. No, determinate lang siya kasi nga we have to distinguish that kasi an indeterminate thing cannot be the object of destruction by a fortuitous event because genus non quam perit or genus never perishes. Tatandaan nyo yan, genus never perishes.
Ibig sabihin yung generic thing never perishes. Kasi pwede mo nga mag-substitute ng iba.
I'll give an example siguro dito. Halimbawa, I promised to deliver a gold watch to Attorney Uy. When I was about to deliver the gold watch to Attorney Oy, I was robbed. Nagkaroon ng robbery, no? So, it's a fortuitous event. It's something na hindi, it's an act of man, in a way, na out of my power to control. So, pwede ko bang sabihin kay Attorney Oy na I have no more obligation to Attorney Oy to deliver the gold watch, the generic gold watch, kasi I was robbed on my way to deliver?
We must make clear that watch is a generic
Generic.
thing.
Gold watch lang naman sinabi ko, walang
gold watch.
specifics.
Hindi. Kasi pwede ka pa namang mag-comply by buying another gold watch of the same quality and of the same kind.
Because of the rule, genus never perishes. Tatandaan niyo yan.
Pero had it been a specific gold watch,
Would have been
nanakaw,
different.
extinguish.
Extinguish ako dito. Oh, yan. May pumasok na extinguishment. Pag-usapan natin ang extinguishment sa last module for obligation.
Module 5.
Module 5. Alright, so we're having a great discussion here. Let's proceed with Article 1166,
Yes,
Attorney Uy.
1166.
Ano ba ang
So,
1166?
the obligation to give a determinate thing includes that of delivering all its accessions and accessories even though they may not have been mentioned.
So may nabanggit dito na dalawa no na obligation daw kapag determinate thing yung i-deliver, kasama rin daw doon na i-deliver mo all, lahat ng accessions and accessories. So, i-define natin ang accessions and accessories.
Even though they may not have been mentioned.
Para rin siya doon sa
Due
due diligence, even if it's not mentioned, parang
may standard of care na
Standard
susundin
of care.
kapag
Dito rin.
may specific real obligation.
dito rin naman, kahit di na pag-usapan na i-deliver ang accessions, by law itself, implied na nakasama yan sa i-deliver nyo. So, pag-usapan natin.
Determinate.
Pag-determinate. Yes, pag-determinate. Pag ang accessions ay the fruits of or additions to or improvements upon the principal thing. So, merong principal thing and then these are additions or fruits of the principal thing itself. So, ano ba example niyan?
Example, house or trees on a land, rents of a building, air conditioner in a car, profits or dividends accruing from shares of stocks.
So, pag-usapan natin yung house or trees on a land, alin ang principal dun?
Ang principal dun is yung land.
Land. So, the principal thing there is the land.
The land.
And the accessions would be...
They are the fruits or just addition to the principal thing.
So, the principal thing actually would exist even without the
accessions.
So, yung bahay na nakatayo doon,
Or yung
tsaka yung
puno
puno
na
na nakatayo doon,
oo.
those are accessions. So, for example, I bought a land from Attorney Uy, let's just say a 100 square meter land, and there are, let's say, 2 mango trees, 3 coconut trees, then there is 1 nipa hat in there. So, those are considered accessions, correct?
Yes.
Now, if I bought the land, what would be Attorney Uy's obligation as regards the accessions, Attorney Uy?
Yes, so assuming that the lot is specific thing, so you include the delivery of the accessions and accessories.
But can
even
you-
though they may not have been expressly
Yes.
mentioned. So kahit wala tayong pinag-usapan na sa'yo yung mga puno doon, it is implied na upon delivery of the specific thing, you include the accessions and the accessories thereon.
Yes, but Attorney Uy, can we make a stipulation na hindi kasama yung 2 puno ng mangga, 3 puno ng coconut at nipa hat? Can we make that?
Yes, we can.
Of course, we can
But it
stipulate.
must be expressly stipulated.
Kasi in the
yung
absence.
yung exclusion na accessories and accession, it must be expressly stipulated.
Exclusion is the exception,
Yes.
not the general rule.
Yes, the general rule is you include all even if not
Expressly
stipulated.
Alright? So take note of that. So kung kayo magbibenta, bibili, yan. Yung mga ganyan, mapapag-usapan nyo dyan. Now, we're done with accessions. How about accessories?
So accessories, these are the things joined to or included with the principal thing for the latter's embellishment, better use, or completion.
Alam mo, actually dito, minsan nalilito yung mga bata.
Oo,
dito,
kung ano ba yung
Kung alin ba
accessories
accessions
versus
of accessories.
So,
So, tingnan natin. Pag accessories, ano ba example niyan?
yung key of a house,
Frame of a picture,
bracelet of a watch, machinery in a factory, bow of a violin.
So, parang nakaka-confuse naman talaga, no?
Oo.
Pero, you have to take note, guys, para ma-differentiate nyo ang accession at ang accessory. Accessions are not necessary to the
Yes.
principal thing. No? The accessory and the principal thing must go together, but both accessions and accessories can exist only in relation to the principal.
So, ang principal mag-exist without the accession and the accessories. But, yung accessions, they are not necessary to the principal. Ano ba yung accessions? Kagaya ng house or tree. Hindi naman kailangan ng principal yun eh. Pero yung accessory, it is needed by the principal.
So, So, for
Must
example
go
nga,
together. For example, sa cellphone.
Mm.
Sa cellphone, yun bang battery, yun ba ay accession or accessory? That is
that
an
is an
accessory.
accessory. Kasi,
Oo.
yes,
Kasi
you
the
have the
principal,
principal.
the cellphone, and the battery, the accessory must go together.
So, for example, the key in the house, they should go together because how can you open the house if you don't have the
Without
key?
key.
Di ba?
Oo.
For example naman sa picture frame, the frame itself is
The picture will not be preserved
yes.
if kung hindi siya
had it
naka-frame
not
or
been for
naka-alt.
that. So, Attorney Uy, nabanggit mo na yung battery,
Oo.
it's actually an accessory to the
Yes.
cellphone. Kasi
Yes.
nga, it cannot function without the battery,
Yeah,
no?
the principal cellphone cannot function well
So, they
without
should
the
go
battery.
together. How about the headset?
Oo. Yung headset, it is considered only as an accession because the principal can exist without the headset, yung cellphone. Pwede naman siyang walang headset, pero hindi siya pwedeng walang battery.
That's correct. Yeah, that's correct. So, take note of that. Siguro isa pa dito yung machinery na factory. So, we know that the factory itself, that's the principal.
Yes.
And the
It cannot
factory
operate or cannot function without the machinery.
So, those are accessories and must go hand in hand with the principal. So, take note of the difference between accessions and accessories that we have,
Yes.
right? Now, what are the rights or what is the right of a creditor to accessions and accessories?
Yes, again, the general rule is that all accessions and accessories are considered included in the obligation to deliver a determinate thing, although they may not have been expressly mentioned. This is because of the principle that the accessory follows the principal. Yun yung civil law principle.
Accessory follows the principal. And in order again to be excluded, there must be a stipulation to that effect. Unless otherwise stipulated, an obligation to deliver the accessions or accessories of a thing does not include the latter. So for example, the
ito
sale of
naman.
a mobile phone.
Yan na yung sinasabi ko kanina. Ito ay magandang example. Yung general rule natin, pag bumili tayo ng cellphone, yung principal, specific thing, bumili tayo ng cellphone, may kasama na siyang charger, may kasama siyang battery, at may kasama na siyang earphones. Yun yung accessions and accessories. Pero kapag bumili ba tayo, for example, ng headset, may kasama ba siyang principal na cellphone? Wala. Okay, bumili tayo ng battery, may kasama ba yung cellphone? Wala.
Ang rule is that
ibig sabihin nun, kapag bumili ka ng principal, you include the accessions and accessories. But when you purchase accessories and accessions, it does not include the principal.
Because it's the accessory that follows the principal, not
the principal.
other way around.
Yes, correct.
So, again, in the purchase of a mobile phone, although there has no mention as to the inclusion of the charger and the earphones or accessories,
you include them.
They should be included. In order for them to be excluded, there must be a stipulation to that.
Yes, yun lang ay exception doon. Yung stipulation na expressly excluding the earphones and the batteries. So, yun.
Kasi by law ang general rule is that they should be
Included even though they may not have been mentioned.
expressly mentioned.
Correct.
Alright, so that's for Article 1166, Attorney Uy. Alright guys, so we've just wrapped up Articles 1163 to 66 of the new Civil Code, and that's the first part of our video lectures as regards our Module 3. And watch out for the next video lectures that we will be uploading there. This has been Attorney Bendrick Ibaralip.
And Attorney April M.
And we'll see you next time. Bye-bye!